and some of them, their lives are being impacted by our discussion, and we want to be upholding the standards, Mr. Chairman, that you have offered, and we want to do this in keeping with the desperate needs of so many. So Mr. Gohmert and I certainly have worked together, and I can appreciate his concern. But I must bring my life experience to the table, and I also will indicate that the language has reason to believe he's correct. It's in other legislation that has not been negated. And so our legislation has a particular focus, and those of us who live in communities where we understand the unfortunate circumstances of racial profiling and the idea that someone may think you are something, there is no doubt that no one will stand against the dastardly acts of MS-13. We've seen them. If you live in this area during the week, you've heard, when I say live in this area, those of us who are not from this region, but we can hear news reports, and we know that there are certain dastardly acts going on under the leadership of MS-13, and we want nothing to do with them. But we also know that young people, those who are impacted, who have a future in life, may be subjected to reason to believe with maybe good intentions, but it may be defined by who you are. And I think that's troublesome, and I think we've written this language in a way that protects the American people, but gives the right balance to make a fair assessment of those who are seeking relief. Section 101C3C of the bill expressly authorizes the Secretary to deny an application if a person has directly participated in criminal gang activities, not passed by the gang, or someone believes they saw something that looked like you. The authority is so broad that the Secretary can even deny an applicant on these grounds when there is no underlying conviction. We wanted to be sure and safe. But for those of us who've interacted with Dreamers and others who we've seen interact in our communities, who we've listened to the desperate pleas of their family members, we understand, or in the instance of those of us who are African Americans who've been fighting against racial profiling for such a long time, it is readily well known. And let me juxtapose this against the good law enforcement and other professionals in and out of the immigration system. There are good people. But we know that the cases of racial profiling are not lacking, and some have even lost their life because of unfortunate circumstances. And so I want to put into the record this particular comment. For example, the gentleman who was nominated to serve as head of ICE by this administration said in a recent interview on Fox News concerning migrant children, maybe little Laura, who's 11 years old, who was unfairly deported because she was in the courtroom and someone overworked, as I said in my earlier statement, told her she didn't need to be in the courtroom, and lo and behold, after coming for 10 times, she got a deportation order, an 11-year-old girl back to El Salvador where they had fled violence. But this is his statement. Nominated to serve as head of ICE, said in a recent interview on Fox News concerning migrant children that he can tell a future gang member by looking into his or her eyes. I've looked at them and I've looked at their eyes and I've said, that is a soon-to-be MS-13 gang member. It's unequivocal. Maybe if you're an African migrant, you are a soon-to-be black identity terrorist. Look into your eyes of 10-month-old Roger that I held in my arms, or look into the eyes of a toddler. Mr. Chairman, let me just say that I appreciate the intent, but I am comfortable with years of experience dealing with these issues on this Judiciary Committee, this august committee, that we have framed it in a way that we will protect the American people, but we will do justice to those who seek justice. I yield back.
Mr. Chairman.
Gentleman from
Virginia.
California is recognized.
Thank you, Mr.
For
Chairman.
what purpose does the gentleman seek
To
recognition?
strike the last word, and I'd
Gentleman is
like to
recognized.
yield my time to Mr. Biggs.
I thank the gentleman for yielding time. And I raise this not to be facetious or to bring jocularity into this hearing. I am serious about this because prior to our recess, someone had mentioned that they had taken a great offense to the term alien or illegal alien. And so a couple of things came to my mind as I looked at that legal term of art, alien, which is actually on page 1, line 13 of the bill itself, and on page 2 is 4 times. If you read the bill, the term alien is repeatedly used. And the reason that it's used is because it's a legal term of art. And so to help the person who is offended so they will know that there's no need to be offended, that we're speaking strictly whatever side, whether you support the bill or don't support the bill, we're talking about in terms of legal language. I was reminded of a song by Sting, which actually explains this term. It's called An Englishman in New York. And in that song, the refrain goes very simply, as he explains through the chorus and the verse that all of the British habits that he retains, that make him British and an Englishman. But he is legally visiting New York. And so the chorus says, I'm an alien. I'm a legal alien. I'm an Englishman in New York. There's a distinction, you see, because an alien means that you're a person who is not a citizen of the country in which you live. You may be legal, you may be illegal. If you're legal, you have obtained the requisite authorization to be in the country as an alien, though you're not a citizen. If you are illegal, it means you have not obtained the requisite authority to be here, though you are an alien. So it's not meant to offend, it is merely meant to convey a legal term and a legal meaning. So again, I'm not trying to be facetious or jocular in any way. I'm just trying to explain it because it seemed like there might have been some confusion on the part of that. And I would just, again, say, if one were to look at the bill that the person was propounding, you cannot find too many pages without apparently the offending language in there. And I'll yield back to the gentleman from California.
Reclaiming my time, I yield the balance to Mr. Goldberg.
Thank you. Appreciate my friend from California. So I was criticized for using the word alien. That's repeatedly used by the chairman in his amendment in the nature of a substitute. I'm sure the chairman didn't mean anything offensive by use of that term alien, just as I did not. And then a little tongue-in-cheek, I was commended for finally joining the joining the Democrats in fighting violence. And obviously, people on this panel ought to know something about the background of the people they are belittling. I've spent a great deal of my adult life fighting violence and fighting it successfully. We have different ways. The ways I used as a prosecutor and as a felony judge for general deterrence, specific deterrence, it was part of my job. I helped diminish violence. So I'm glad to have some of my Democratic friends coming late to the game to join me in that fight. We see that MALDEF, and I'm not sure what that stands for, but apparently they've sent out word to my colleagues across the aisle that they are opposed to the Gohmert Amendment. And I'm sure they didn't do it intentionally, but mischaracterized the amendment. They said that this amendment would expand the definition of criminal gang participation to define gang membership to include being listed on a federal, state, or local gang database. And that's simply not the case, so they don't have to worry. They're wrong about that. What it does is allow the secretary to consider all credible evidence of membership, participation in a street gang, including evidence that may be obtained through a database. But there has to be sufficient evidence in the database that would be appropriate to be considered and used. And the article, I know someone was offended when it said I was getting out of control when I mentioned being beat by a baseball bat and stabbed repeatedly with a machete. That's from what just happened by an alien who was in the country illegally, and multiple aliens, and part of a gang, and that's what they did to this 14-year-old girl. I yield back.
Gentleman yields back. The question occurs on the amendment. All in favor of the amendment say aye. Aye. All opposed say no. No. The noes have it. The amendment is not agreed to. A roll call is requested. The clerk will call the roll.
Mr. Nadler? Mr. Nadler votes no. Ms. Lofgren? Ms. Lofgren votes no. Ms. Jackson Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu? Mr. Liu votes no. Mr. Raskin? Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Ms. Demings? Ms. Demings votes no. Mr. Correa? No. Mr. Correa votes no. Ms. Scanlon? Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse? Ms. McBath? Mr. Stanton? Ms. Dean?
No.
Ms. Dean votes no. Ms. McCarcel-Powell?
No.
Ms. McCarcel-Powell votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Collins? Mr. Collins votes aye. Mr. Sensenbrenner? Mr. Shabbat? Mr. Gomert? Mr. Gomert votes yes. Mr. Jordan? Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Ms. Lesko? Ms. Lesko votes aye. Mr. Reschenthaler? Mr. Reschenthaler votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Stubbe? Mr. Stubbe votes yes. Mr. Cohen votes no. Mr. Deutsch votes no. Mr. Neguse votes no. Mr. Chairman, there are 10 ayes and 17 noes.
Gentleman from Colorado.
I have an amendment to this, Mr. Chairman.
I reserve a point of order.
Clerk will report the amendment. The gentlelady reserves a point of order.
Buck number 1 to ANS for HR 2820 description. Provides that the Secretary shall have access to the Interstate Identification Index System, 3 system, which is accessible by way of the National Crime Information Center, NCIC, portal when conducting any of the background checks required by this legislation. This access will allow the USCIS to adjudicate applications more efficiently and accurately.
Without objection, the amendment is considered as read. The gentleman is recognized to explain his amendment.
Thank you, Mr. Chairman. Mr. Chairman, I have looked high and low for common ground with the chair of this committee, and I think I have found it with this amendment. My amendment is very simple. What it does is it allows the United States Customs and Immigration Service access to the very best and most comprehensive background check database the government has in order to assess whether an applicant has a criminal history. According to USCIS, the right database is the full Interstate Identification Index, or III, Interstate Identification Index, III database. USCIS needs access to this database to conduct background checks. Without access, the agency will not be able to tell us whether an applicant poses a public safety or national security risk. In addition to the benefit of denial, certain information may establish grounds for administrative investigation, criminal referral, and initiation of removal proceedings. USCIS has needed access to III for some time. Since 2013, they have adjudicated nearly 50 million benefit requests without full access to criminal history records of the applicants. My amendment will give USCIS access to the III database so that they can use that in processing applications filed in response to this bill. This is the right thing to do. We should not tie DHS's hands by denying them access to critical information. We should let DHS fully vet applicants using the best information we have available. 9/11 happened because Congress allowed a wall to remain in place. That wall denied access to critical intelligence information to domestic law enforcement agencies. Today, a similar wall is in place that denies USCIS access to the best information available about a foreign national's criminal history. We need to tear down that wall. We need to give USCIS the right tools to do the job that Congress is directing them to do. Mr. Chairman, I have heard on the last amendment a number of my colleagues on the other side of the aisle talk about the need for and how this bill includes public safety safeguards. This amendment just gives the government access to information that it needs to make that evaluation. And I would ask for the full committee's support, and I yield back. Yes.
Pardon the ignorance, but exactly what is the Interstate Identification Index 3 system that you reference here?
So, Mr. Chairman, there is a national, an NCIC, National Information System,
Right.
Criminal Information, and then there is a state. So in Colorado, we have the CCIC. Not all states allow criminal information to go into the NCIC, and not all states allow criminal information. I'm sorry, not all states allow criminal index information to be used by non-law enforcement agencies. USCIS is a non-law enforcement agency. It is not like the FBI or other law enforcement agencies. So this would give the...
Reclaiming my time, if it's my time.
You can have it.
The bill says, the sentence that you want to amend, says the Secretary shall use biometric, biographic, and other data that the Secretary determines appropriate to conduct security and law enforcement background checks and to determine blah, blah. You would add, the Secretary shall use all this data that he deems appropriate, including checks in this system. My first question is, if he deems it appropriate, can he do it under the terms of this bill without your amendment?
No, because he doesn't have access to criminal information. This is not a criminal agency and doesn't have access to criminal databases. So They need Congress to authorize.
So what kind of information would there be here that he wouldn't have access to?
So an individual who is convicted in one of the states, and I can list those states for you if you'd like.
Don't list the states, just go ahead.
Oh, there's 11 of them, and they include California and Texas,
Okay, all right.
relevant states for our purposes in
For those
immigration.
states, what would this do?
Those states prohibit non-law enforcement agencies having access to the data that they put into NCIC.
So this would
Overla-
override the state prohibition.
This would allow Congress, this would designate USCIS for this purpose to have access to that information.
Despite the state prohibition.
Well, the states are prohibiting it from being used for a criminal database check.
Okay, I think I understand what you're talking about now.
Mr. Chairman,
Mr. Chairman?
Mr.
Let
Chairman,
me just say, before I recognize anyone else, I am inclined to say that this amendment may be okay. I'm not prepared to accept it now, because we really have to look at the implications of it, and based just on the very spare information we just got, it's not enough. But I'm prepared to work, if you withdraw the amendment, we'll work with you toward seeing if it makes sense to put it in before the bill, gets to the floor. I'm not making a commitment to do it or not to do it, except to explore it, because I really don't know at this point.
Would it be possible to re-offer it at the end of the markup?
I'd have to oppose it because we don't have nearly enough information. Before the floor, we'll consider it, we'll talk with you, and maybe we'll say yes and maybe we'll say no, I don't know. But let me just say this. We're not gonna know I don't know that we'll know a heck of a lot more before the end of the market. Maybe we will, I don't know. So I won't make a commitment on that.
Well, I'll ask, I will withdraw it now. I'll ask the chair at the end of the markup whether the chair would be willing to consider my amendment at that time.
Sure.
Could we ask for postpone? Just
Yes,
postpone the
yes.
consideration of this
Certainly,
amendment, then
certainly.
because this is gonna be a long markup, they can do that.
Certainly.
Great. I will do
You
that.
can withdraw the amendment without prejudice. You can offer it again later. I may have the same answer, we may have a different answer, we'll see.
I will withdraw the amendment, Mr.
The
Chairman.
amendment is withdrawn temporarily. Are there any other amendments? The gentleman for what purpose does the gentleman from Arizona seek recognition?
I have an amendment at the desk.
Gentleman,
I re-
clerk will report the
I
amendment.
reserve a point of order.
And the gentlelady reserves a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 2820, offered by Mr. Biggs of Arizona.
The amendment is considered as read, and the gentleman is recognized to explain his amendment.
Thank you, Mr. Chairman. My amendment deals with confidentiality, and H.R. 2820 contains an expansive confidentiality provision that prevents information contained in an application from being used for certain law enforcement purposes, including immigration enforcement. The bill specifically states, and I quote, "The Secretary may not disclose or use information, including information provided during administrative or judicial review, provided in applications filed under this Act or in requests for DACA for the purpose of immigration enforcement," close quote. Instead, the information can only be shared with law enforcement authorities for considering the application, national security purposes, or investigation and prosecuting felony offenses not related to immigration status. This would allow aliens who submit fraudulent applications that prove they are illegally in the United States to escape prosecution or deportation. Similar confidentiality provisions in the 1986 amnesty incentivized widespread fraud in the program and have hampered law enforcement efforts. My amendment would strike the confidentiality provisions in the bill and replace them with the regulations that are currently in place for aliens applying for temporary protected status. This would allow for information in the applications to be used by Department of Homeland Security or any federal or state law enforcement agency for enforcement of the Act or in any criminal proceeding. Given that currently there are more than 400,000 people who have temporary protected status, these privacy regulations clearly are not serving as a deterrent to filing honest applications. It's disappointing that efforts weren't made to prevent fraud in the system, but I believe this amendment is a step towards rooting out fraud, and so I would encourage everyone to support my amendment, and with that, I yield back.
The gentleman yields.
Mr. Chairman,
Gentlelady from California. For what purpose does the gentlelady seek recognition?
I move to strike the last word, and I withdraw my reservation.
Gentlelady is recognized.
I oppose the amendment, although I am sure it is well-intentioned. We do have some fraud prevention provisions in the bill, but the confidentiality provisions in the bill are very important. Confidentiality has been recognized as critical to the success of a variety of immigration benefits and initiatives, including VAWA, U-Visa, special immigrant programs, as well as previous legalization efforts. Confidentiality provisions are critical to gaining the trust of qualified individuals and to yield maximum participation, and this bill is no different. What is different in this bill is the narrowness of the confidentiality provisions. Past bills have prohibited the use of information provided by applicants for any reason other than to make a decision on an application, but this bill actually provides for much more. It allows such information to be shared to identify and prevent fraudulent claims for national security purposes or for the investigation or prosecution of any felony offense not related to immigration status. All applicants under this bill, those who've never been in removal proceedings and those with final removal orders, will be asked to come forward and disclose sensitive information related to their immigration status, their immigration history, their lack of current status, and they will likely need to disclose sensitive information about their family members as well. The President and his immigration and his administration have been hostile to immigrants in their rhetoric from the beginning, and the immigrant community is understandably fearful, and I would say justified in their concern about what might happen with this information if there are not clear limitations set forth in the bill. And for this reason, the confidentiality provisions in the bill prohibit the use of information disclosed in applications for immigration enforcement purposes. Now, if this prohibition is watered down or even removed, information disclosed in any application could be used for any purpose, including targeting family members for enforcement, and that would defeat the very purpose of this bill. I think the bill takes a very smart, balanced approach to confidentiality by giving assurances to applicants that their information will not be used for immigration enforcement while giving more than enough leeway to DHS and other federal law enforcement agencies to carry out their mission. So I think this amendment is unnecessary and also destructive of the confidentiality provisions included in the bill. I would point out further, as I said earlier, the bill's limits are narrow. Information could be used for fraud, national security purposes, or prosecution of non-immigration felony offenses. And with that, Mr. Chairman, I would yield back.
Mr. Chairman,
Gentlelady yields back. For what purpose does the gentleman from Georgia seek recognition?
move to strike last word.
Gentleman is recognized.
Thank you, Mr. Chairman. Look, I'm in support of the amendment. I think it's really interesting, and I appreciate the gentlelady from California. We've had some great conversations about this over time, and especially some of the best conversations we've had about the coming forward and giving information has come from your side, especially our former member, our gentleman from Chicago, Mr. Gutierrez, who was very critical of the DACA program because of the very things that you just cited. And I think that is something that's really interesting here, because the very program that President Obama actually put forward was causing people to actually have to do some of the similar things. So it's an interesting point to make now in opposition to, as the very program itself caused this to happen. So with that, I yield to the gentleman from Arizona.
I thank the gentleman from Georgia, and I just want to point out something that I think is important for clarification. I see people in our audience that are wearing T-shirts that say Save TPS, and I get that, because we're going to consider two bills dealing with TPS later in this markup session, whether it's today or tomorrow or whenever it may be. But I am a little bit baffled, because I look at the ANS to HR 549, and this is for the TPS for Venezuelans, and that's an interesting thing, because my amendment provides the same confidentiality that the majority's 549 is going to apply to all those TPS applicants. And I'm trying to understand why you're comfortable with that kind of confidentiality requirement for the Venezuelans seeking TPS, but you're not comfortable with it for DACA and in this particular bill. I do think that my proposed amendment provides adequate confidentiality, but it also helps prevent fraud. And that's really, we're trying to find that sweet spot. Apparently we found it in TPS, but that's not quite good enough for this. I would urge everyone to reconsider and vote for my amendment. With that, I yield
Would the
back to
gentleman yield?
Georgia.
Gentleman yielded back. Who seeks recognition? Gentlelady from Texas, Ms. Escobar.
Thank you, Mr. Chairman.
I had mine up too, never mind.
Ms. Escobar is recognized.
Thank you. Move to strike the last word.
Last word is duly struck.
Mr. Chairman, I oppose this amendment. And as Ms. Lofgren mentioned, the confidentiality that's been crafted so far is something that has gone through significant vetting and debate and discussion internally between many of us who are all along the spectrum on this particular bill. But I want us to remember that dreamers were promised something. And that promise was made years ago. And even when our current president ran for office as a candidate, he promised dreamers that he would protect them. That promise, we saw, was broken. And it was broken even after these vulnerable young people provided the government with all of their information because they believed that the promise was going to be kept. After that promise was broken, we then witnessed, in my community firsthand, El Paso, through the Tornillo Child Detention Facility, we witnessed firsthand how children were used as a lure for their families, and it was a trap in order to try to create more of a deportation mechanism for family members. And so why would we believe at this point that this administration can be trusted with the most vulnerable information for a population who was promised relief over and over and over again, only to see that promise broken over and over and over again? Ms. Garcia, I'm happy to yield to you if you like.
I thank the gentlelady from Texas. And Mr. Chairman, I too, I want to speak against this amendment. As Ms. Lawford has already stated, if this is about preventing fraud, that is covered under the current bill as amended. And if this is as broad to mean any reason, I think it would have a very negative, chilling effect on many of the folks that we represent. I know in my district, where we have many thousands and thousands of dreamers and is a heavily Latino population district in Houston, if people knew that information was going to be shared and confidentiality would be breached, people probably wouldn't apply, and they would ask people not to apply because they would be in fear of what retaliation or what else may happen, not just to them, but everyone in their household. They wouldn't feel safe to go to school. They wouldn't feel safe to go to church, to go to a hospital, to go to a courthouse. There would be no safe place in our communities. So I strenuously rise to oppose this amendment. I think that the approach that's been used in the bill is very balanced and covers all the critical needs for any of the agencies that he is discussing.
Would the gentlelady yield?
Sure.
I reclaim my time.
You reclaim your time.
Yes,
Would
yes.
the gentlelady yield?
The
For a
gentlelady
quick
from
question,
Texas,
if you
Ms.
have a quick
Escobar, has
question.
I do have a question.
Okay, I yield.
Thank you. My question is the concern that you have is that this will it'll provide a chilling effect if my amendment were in place. I guess my question is, you don't see the same chilling effect on the TPS bill, HR 549 that we're going to consider? Why is this uniquely different? And then as well, can we deport somebody if we determine from their application that the individual is ineligible. The provisions under the current bill doesn't seem to indicate that that would be possible. So that's the kind of question I'm trying to get at.
Mr. Biggs, thank you. If we could have made those amendments and offered more confidentiality to TPS recipients, I would have liked to have done that. This population, again, very vulnerable, we've made a promise to them, promises that were made by a prior administration, promises that were made by a candidate who then became President of the United States, promises that have been not kept. And communities, vulnerable communities, are living in fear. And so if we want folks to come forward and to provide all that information, we have to protect them. And so I think the protections that already exist against fraud in the current bill are sufficient, and I yield back.
Gentlemen, who seeks time? The gentleman from Louisiana.
Mr. Chairman, I would oppose the amendment for all the same reasons, but I'd like to yield a few minutes, 2 minutes to Zoloff.
Thank you. I just thought it would be important to put into the discussion here the actual language in the underlying bill of what can be shared. For assistance in the consideration of the application for justice of status under this act, to identify or prevent fraudulent claims, for national security purposes, or for the investigation or prosecution of any felony offense that's not related to immigration status. So I think anything that is a concern raised by this amendment is covered in the underlying bill, but the threat that immigrants feel is palpable. And I know that as a Californian, that, you know, I've got constituents who are U.S. citizens with legal permanent resident spouses who are afraid to get an official document. So the level of fear is very high, and if we don't have confidentiality in this process other than for these exceptions, we will really chill participation. And I thank the gentleman very much for allowing me to speak, and I yield back to Mr. The gentleman has the time.
Would my friend from Louisiana yield to me?
Sure.
Thank you. And I just real quickly, and I understand the argument here of chilling, and that was actually argued, as I said just a few minutes ago, by Mr. Gutierrez when he was here. That was one of his biggest arguments against the DACA program itself, is that it forced this problem. But I don't think the chilling effect, and we can argue about how and not, but there's been 400,000 folks apply for TPS. It's not seemed to be a chilling effect in that regard. And I think, applying the same standards, is something that could be valid here. And I appreciate the gentleman from Louisiana yielding.
I still disagree with you, and I yield back.
The gentleman yields back. The question occurs on the amendment. All in favor of the amendment say aye. Aye. Opposed, no? No. The amendment is not adopted, is not agreed to. Roll call vote is requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass? Mr. Richmond? Mr. Richmond votes no. Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu? Mr. Liu votes no. Mr. Raskin? Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Ms. Demings? Ms. Demings votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse? Mr. Neguse votes no. Ms. McBath? Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Steen?
No.
Ms. Steen votes no. Ms. Mucarsel-Powell? Ms. Mucarsel-Powell votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Collins? Mr. Collins votes aye. Mr. Sensenbrenner? Mr. Sensenbrenner votes aye. Mr. Shabbat? Mr. Gomert? Mr. Gomert votes aye. Mr. Jordan? Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Ms. Lesko? Ms. Lesko votes aye. Mr. Reschenthaler? Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Stubbe? Mr. Stubbe votes yes. Mr. Deutsch votes no.
Are there any other members who wish to vote who haven't voted? The clerk will report.
Mr. Chairman, there are 10 ayes and 18 noes.
The amendment is not agreed to. Are there any further amendments? For what purpose does the gentleman from California seek recognition?
I have an amendment at the desk.
I reserve a point of order.
The clerk will report the amendment. The gentlelady reserves a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 2820, offered by Mr. McClintock of California.
The amendment will be considered as read. The gentleman from California is recognized to explain his amendment.
Thank you, Mr. Chairman. One of my many objections to this bill is that it sets a lower threshold for illegal immigrants to obtain green cards than we have for legal immigrants. My amendment simply applies to illegal immigrants in this bill the longstanding discretion that the DHS Secretary has had when determining eligibility for immigration benefits, including adjustment of immigration status. I offer this amendment to test whether the majority really believes that illegal aliens should be treated better than legal immigrants who've respected our laws and done everything our country's asked of them. As it's written, H.R. 2820 strips the Secretary of his current authority to consider discretionary factors when determining whether an illegal immigrant is eligible to receive permanent lawful residence in our country. The special path to citizenship that H.R. 2820 offers is a significant benefit, essentially the keys to our country. Under our law, the vast majority of other immigration benefits provided through the Immigration and Nationality Act, including adjustment of status, are discretionary, and the legal immigrants must demonstrate that they merit the status in the exercise of that discretion. But this bill states that the Secretary shall adjust the status of an alien, so the Secretary cannot consider discretionary factors that weigh in favor or against granting such status. Under the bill as written, illegal aliens arrested for heinous crimes but not yet convicted would get green cards. Aliens who commit heinous acts but who are not convicted for technical reasons would get green cards. The alien is technically eligible, the Secretary must grant the benefit and is powerless under the law to deny it. The illegal aliens given green cards under H.R. 2820 should be no different than any other alien who tries to adjust status. The Secretary should be able to consider discretionary factors that weigh in favor of or against granting such a status. Of course, the change from shall to may in my amendment is consistent with other parts of the Immigration and Naturalization Act. It does not mean unfettered discretion. The Secretary cannot abuse the discretion, but a mandatory benefit will constrict determinations that are best left to the agency experts who know all the facts about a specific case as they carry out the truly serious responsibility of providing benefits under H.R. 2820, which includes a green card and a path to U.S. citizenship. I'd urge my colleagues to support the amendment.
I recognize the gentleman yields back. I recognize myself in opposition to the amendment. This amendment basically cancels the entire bill. What the bill says is that if you meet certain requirements, you are entitled to certain benefits, namely to a path to citizenship and so and to stay here and to have a path to citizenship and so forth, if you meet the requirements established in the bill. And I don't have to go through what those are, we all know them. What the amendment says is, if you meet the requirements of the bill, the Secretary may cancel the removal instead of shall cancel. In other words, the Secretary could abolish the entire program with a stroke of his pen. Or he could cancel half the program with a stroke of his pen. Or he could say, the program continues except for Joe. I don't like Joe. So Joe doesn't get admitted under the Dreamer, as a Dreamer, even though he meets all the requirements of a Dreamer. This makes the program entirely discretionary as opposed to a mandatory program. The whole idea of the bill is we are establishing a program. Congress is deciding that people who meet certain requirements, they were brought here under the age of 18, before a certain date, they haven't misbehaved, they haven't committed crimes, they're not whatever, are entitled to a path, are entitled to stay here, are entitled to work permits, are entitled to a path to citizenship. That's the purpose of the bill. What this amendment very innocently says in 4 places is the word shall be replaced with the word may. It makes the entire bill discretionary with, not only with the Secretary, but with any Secretary. The current one is good and says okay, and the next one is bad and says no. And the guy who comes in afterwards says, anybody still remaining in the country, it'll be okay again. Or on an individual basis. It's absurd unless you're opposed to the bill. If you're opposed to the bill, then vote against the bill. But don't make the bill entirely discretionary on an absolutely arbitrary basis, and period. So we have to oppose the amendment. The amendment basically says, never mind the whole bill. I oppose the amendment. I yield back.
Mr. Chairman. Move to strike the last word. Move to strike the last word. And I yield my time to Mr. McClintock from California.
I thank the gentleman for yielding. I simply wanted to point out that the chairman has just very accurately described the discretion that the DHS secretary already has for every other alien who applies for a green card. That's already in the law. If you're a legal alien who has obeyed all of our laws, who has waited patiently in line, who's done everything our country's asked of them, the secretary's discretion applies. Under this bill, though, if you have entered the country illegally, then you are automatically granted these meeting certain requirements without any ability of the DHS secretary to exercise discretionary judgment. The secretary cannot abolish the program, cannot abuse the discretion. There's a long line of case law on that. And what this essentially does is place the interests of those who broke the law above the interests of those who've waited patiently for a green card. It's a double standard, and I'm testing whether the Democrats on this committee actually intend to impose that double standard and elevate illegal immigrants to a higher level of recognition than we accord to the legal immigrants who have obeyed our laws.
Mr. Chairman.
Mr. Chairman,
Gentlelady from California.
I move to strike the last word.
Gentlelady's recognized.
I appreciate my colleague from California's amendment, and I'd like to note that we have built into the rest of the act the discretion that he urges. The Secretary has the discretion to prevent the application of people who he feels are a threat to public safety, who are a threat to national security, and the like. I understand that the point being made, but these individuals are de facto Americans. These are individuals who've grown up here, who, I can't tell you the number of people I've met who they found out when they went to apply for a loan to college for the first time that they weren't an American citizen, much to their shock. So I understand the point being made, but this is a category of individuals that is in a rather unusual situation. We have discretion for the Secretary built into other parts of the bill, and I would yield to the chairman for comments he may
I
wish.
thank the gentlelady, and I would point out that there is discretion in the bill with reference to what the bill deems should have discretion. People who may have committed crimes, people who may be dangerous to public safety, and so forth. It's in the bill. But the basic purpose of the bill is to say that this category of citizens, not people who did anything illegal, they were brought here as children. It's not their discretion generally. 1-year-olds don't make decisions, nor do 7-year-olds for that matter, as to where they're going. People who are brought into this country as children, who have grown up here, who are de facto Americans, the whole point of the bill is to say there should be no discretion unless they've misbehaved in some way and forfeited the protection of the bill by some act or series of acts which the bill lists. But other than that, there should be no discretion because Congress is deciding that this class of people are in fact Americans and should be given a path to become American citizens. Yes, there's normally discretion in the immigration law. The whole point of this bill is to say, but not for people who were brought here as children. If you don't agree with that, you should vote against the bill. The amendment simply cancels the bill. So if you support the bill, you vote against the amendment. If you want to vote for the amendment, you're really voting against the entire bill. And there's nothing else to say about it. Therefore, I oppose the amendment, and the gentlelady yields to the gentleman.
I would yield to Mr. Correa.
Thank you. I just want to remind my colleague from the state of California that California is the home to the greatest number of dreamers in the state of California. Want to remind folks who dreamers are. They've been vetted, they work hard, pay taxes, they're law-abiding, and they're also police officers. Germán Martinez Garcia grew up in Southern Illinois, and in the words of his police chief, he's part of this community, he's a good citizen, he's a good person, we need him on the force, and he is a dreamer. And here's a picture of him. A dreamer who is a police officer. I yield, Mr. Chairman.
Mr. Chairman, unless there are other, Mr. Cicilline, I would yield to Mr. Cicilline.
I thank the gentlelady for yielding. I want to just underscore the point of the chairman. The notion that children who came here, some in the arms of their parents as infants, broke the law is a ludicrous claim. A child, an infant, a 3-year-old doesn't have the capacity to break the law. In fact, they have no capacity to resist their parents if they came to America. So this notion of they're the same as others who are in this country undocumented, and this treats them in a preferential way, as the chairman said, I don't know if people forgot our hearing. We had Jin Park, a Korean national who's a Harvard graduate and a Rhodes Scholar. We had people who are finishing their studies and PhD, becoming physicians, becoming community activists. These individuals have contributed enormously to the story of this country, the story of America. They've made us a stronger, more vibrant, more dynamic country. And these are individuals who came with their parents, often fleeing unspeakable violence and difficult circumstances, and who know no other country but America. This is their home. And the chairman is right. If you vote for this amendment, you are voting to end the DREAM Act, because it ought not be a discussion. We've decided as a matter of policy, these individuals are every bit as American as everyone else, but for a piece of paper. And that's what this bill is designed to correct. So I urge a no vote on this amendment. And
Question occurs on the amendment. All in favor of the amendment will say aye. Aye. Opposed, no? No. The noes have it. The amendment is not agreed to. Roll call vote is requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Lofgren votes no. Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia votes no. Mr. Deutsch, Ms. Bass, Mr. Richmond, Mr. Jeffries, Mr. Cicilline. Mr. Cicilline votes no. Mr. Liu? Oh, Mr. Liu votes no. Mr. Swalwell? Mr. Raskin? Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Ms. Demings? Ms. Demings votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse? Ms. McBath? Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Steen?
No.
Ms. Steen votes no. Ms. Mucarsel-Powell? Ms. Escobar? Mr. Collins? Mr. Collins votes aye. Mr. Sensenbrenner? Mr. Sensenbrenner votes aye. Mr. Shabbat? Mr. Shabbat votes aye. Mr. Gomert? Mr. Jordan? Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Ms. Roby? Mr. Gates? Mr. Gates votes yes. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Ms. Lesko? Ms. Lesko votes aye. Mr. Reschenthaler? Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Stubbe? Mr. Stubbe votes yes.
Are there any members who wish to vote who haven't voted yet? Gentleman from Texas.
Mr. Gomert votes yes.
Gentleman from Florida.
Mr. Deutsch votes no.
Gentlelady from Florida.
Ms. Mucarsel-Powell votes no.
Okay. Is there anyone else who hasn't voted who wishes to vote? The clerk will report. Have you voted? Val, have you voted? Val. Madam Clerk, is the gentlelady from Florida recorded? Is Ms. Demings recorded?
Ms. Demings, you are recorded as no.
Okay. Thank you.
Mr. Chairman, there are 12 ayes and 16 noes.
The amendment is not agreed to. Are there any further amendments?
Mr. Chairman,
For what purpose does the gentlelady from Arizona seek recognition?
thank you, Mr. Chairman. I have an amendment at the desk.
I reserve a point of order.
The clerk will report the amendment, and the gentlelady reserves a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 2820, offered by Ms. Lesko of Arizona.
I withdraw my point of order.
Point of order is withdrawn. The gentlelady will explain her amendment.
Thank you, Mr. Chairman. This amendment makes 212A 6C, fraud, material misrepresentation, a ground of ineligibility. 212A6C applies to anyone applying for a green card or visa. Basically, what it says is that an alien who by fraud or willfully misrepresenting a material fact seeks to procure or has sought to procure or has procured a visa, other documentation, or admission into the United States or other benefit provided under this chapter is inadmissible. It also says under C, 2 I's, and any alien who falsely represents or who has falsely represented himself or herself to be a citizen of the United States for any purpose or benefit under this chapter, including Section 1324A, unlawful employment of aliens or any other federal or state law, is inadmissible. Basically, Mr. Chairman and members, my amendment ensures that DACA applicants under this bill who have committed fraud, material misrepresentation, or who have made a false claim to the U.S. citizenship to obtain benefits for which they are not entitled should not be rewarded for their action. All other aliens who apply for permanent residence are subject to 212A6C and are excluded if they have committed fraud or material misrepresentations or made false claims to U.S. citizenship. And why should DACA recipients under this bill get a benefit that anyone else applying for a visa or green card has to go through? I don't think they should. And that's why I'm doing this amendment. And before I close, Mr. Chairman, I want to remind the members that last year, and the audience, that last year we had a bill that would have given DACA recipients legal status. It was combined with other provisions, including reforms for asylum to make sure those that were credibly in fear of their lives would get asylum, but cut down on frivolous claims. It also would have secured the border, and none of my Democratic colleagues voted for that. So with that, I yield back my time.
Gentlelady, yield back her time. The gentlelady from California, for what purposes gentlelady seek recognition?
To strike the last word.
Strike last word? Gentlelady is recognized.
I oppose this amendment. This is a provision that is generally forgiven in legalization bills, and the reason is there can be many instances where, although it's willful, it's not malicious, if that's the right word. I mean, I'm not talking legal words. And I'll give you an example. If you take a look at the Immigration and Nationality Act that the gentlelady refers to, an alien who by fraud or willfully misrepresenting a material fact secures other documentation. You could, in fact, have a child who was brought to the United States say to their school that they are a U.S. citizen, and they would be, which happens from time to time, and they would be barred under the gentlelady's amendment from having the benefit of the DREAM Act. I don't know if that's what was intended, but that could be the effect, and I think that would be contrary to what we're trying to do with the bill. There is an exception for individuals prior to attaining the age of 16, but certainly there are plenty of young teens, I've met them, who at age 17 have made such representations who would be covered by this amendment. I think that we should not approve this, and I therefore oppose it and yield back, Mr. Chairman.
Do you please yield me some time to respond?
I'm sorry, I yielded back.
Mr. Chairman? Mr. Chairman?
Lady?
Thank you. In response to what was just said, I want to remind everyone that there is an exception, and I'm just going to read it. In the case of an alien making a representation described above in I, if each natural parent of the alien, or in the case of an adopted alien, each adopted parent of the alien, or is or was a citizen, whether by birth or naturalization. The alien permanently resided in the United States prior to attaining the age of 16, and the alien reasonably believed at the time of making such representation that he or she was a citizen, and the alien shall not be considered to be inadmissible under any provision of this subsection based on such representation. So I believe that there is an exception which I was proposing to
The
include.
gentlelady, or the gentleman, whoever has it, the gentlelady yield for a question?
Yes, I will.
So under what you just read, a 16 or 17-year-old whose parents are not citizens, who misrepresents that he is a citizen and actually thinks he is, would be barred, correct?
I'm not sure if that's correct, sir.
Well, given what you've just read, the exception that you read does not cover that because it says one or both, I don't have it in front of me, but you just read one or both parents are citizens. And what it's saying is that if he made a material misrepresentation, namely he said he was a citizen or she, and one or both of his parents were citizens, then he's not barred. But if neither of his parents are citizens, the clear implication, even if he thought he was a citizen, he didn't know that he was making a misrepresentation, he would be barred. And that's why this amendment is frankly dangerous in unforeseen circumstances, unnecessary, and I would urge people to oppose it.
Would the gentleman yield?
And do I still have time? I believe I have time.
Yes, you do.
I've got the
So-
time, the
Gentleman from Ohio
gentlelady can
controls the
continue to have the time. I yield to the gentlelady.
Thank you, Mr. Shabbat. Well, you know, clearly, this is already law, and to me, it is unfair to put illegal aliens in front of people that are trying to enter our country legally, especially when they have committed fraud or willfully misrepresented material facts. I don't understand the objection, and so I yield back my time.
I'll
Reclaiming my time.
Gentleman from
My
Ohio.
time. Yeah. I guess before my time runs out, I just want to, again, just make the point, without the gentlelady's amendment passing, just as without the gentleman from California, Mr. McClintock's amendment being passed, essentially what we're doing is we're treating people that broke the law, people that came here illegally, better than people who tried to do it the right way. And to me, that makes absolutely no sense. I would also make the point that when you say that these children didn't come here of their own volition, they were brought here by their parents, if we give them favors that other people wouldn't get, essentially you're inviting more people to see what those parents did, and their children got to be legal. You're inviting a whole lot more people to do the same thing, to break the law, to come here illegally, and that's why we haven't solved this problem for literally decades now, and this passage, without this amendment, just makes it even worse. And I yield back.
I recognize myself in opposition to the amendment. Ms. Lesko just pinpointed, and Mr. Shabbat too, really the heart of the bill. We are granting, by this bill, a right to people who didn't break the law. They're kids, or they were kids at the time. They didn't break the law. They were brought here, period. Not by their own volition. And yes, we are saying that people who were brought here as minors, who may have been a year old or 8 years old or whatever, for all practical purpose, and may not even have known that they weren't born in the United States, that they weren't American citizens, and maybe their younger siblings were born in the United States and don't even find out about it until they apply to college or for a work permit when they're 16. Yes, the point of this bill is to say we are going to treat them, we're going to establish a path to legalization for them, and we're not going to nitpick because we recognize that for all practical purposes, they're Americans and we want them to be Americans, and period. To say that someone who inadvertently, and this is the amendment, I mean, that argument is really on the bill, to say that someone who materially misrepresents by saying he's a citizen when he thought he was, and his parents aren't citizens, therefore he can be excluded, goes against the whole point of the bill. And yes, people who come here our whole system of immigration and the preferences is a whole separate debate. And we're not going to get into that now. But people who were brought here as kids, we are establishing, in effect, a preferential system because we recognize them as Americans. That's the point of the bill. If you don't like that, you're against the bill.
With the gentleman.
Fine. But we shouldn't put in gutting amendments which will find, this isn't the gutting amendment, I'm sorry, amendments which every so often will find an unwitting victim for no particular reason and say to this 15-year-old kid, you're out. That doesn't make sense, and I oppose the amendment. I'll yield to the gentlelady from California.
I thank the gentleman for yielding. False claim to citizenship does not require intent. And I remember a case that we were working on, just an individual case of a baby whose parents had filed a false birth certificate who was barred from entry under false claim to citizenship. I remember, Mr. Gohmert, if you'll permit me to recall, you had a constituent who ran a small business. Remember this? We tried to work on this, where he filled out his A number, but also filled out that he was a U.S. citizen. He was deported because there's no excuse for false claim to citizenship. So this is really not, I don't question the motives, but I think this is not a good amendment if we're trying
It's
to...
Jeff in High Def, and you're watching your guide to everything live, livemediaguide.com.